May it please the court. This was a mistake, not mistreatment. Mr. James Washington made a parenting mistake. He was frustrated with his son's slipping grades, how his son was avoiding household chores, and his son's disrespectful attitude. Mr. Washington had enough. You've now heard from Mr. Washington how his son Ryan continued to disrespect him on January 1st, 2017. You heard how Mr. Washington started his day hoping to unwind by watching football, having a few beers, and grilling. You heard how he caught Ryan stealing a beer from the fridge, how Ryan had been avoiding Mr. Washington all day, and eventually, later, Ryan started swearing at Mr. Washington, saying, "Go fuck off, you motherfucker." Ms. Washington was not parenting under her own roof, so Mr. Washington parented his own child. Parenting is not mistreatment. You've heard from Ann Walker, the DCF investigator, about how Mr. Washington did not abuse Ryan. The DCF investigation found the abuse was unsubstantiated. That DCF investigation found that, according to the preponderance of the evidence standard, the same standard used by this court in this proceeding, that there was no abuse. And still, the DCF found that the facts and circumstances do not show a finding of abuse. It was not mistreatment. You've heard from Ms. Washington, who stands to get sole physical and legal custody of Ryan should you grant this protection order. You heard how Ms. Washington failed to parent her own son under her own roof. You heard how Ms. Washington called the cops when her husband did discipline Ryan. And even then, her story changed. Ms. Washington reported to police that Mr. Washington had put his hand around his son's neck. But this is not true. First, the police did not find any markings on Ryan's neck. Second, Mr. Washington himself states that he did not put his hand on Ryan's neck. And third, Ms. Washington herself later wrote in Ryan's protection from abuse petition that Mr. Washington only put his hand on Ryan's chest. Mr. Washington's actions were not mistreatment. Finally, you've also heard from Officer Owens, who clearly testified that Ryan did not suffer significant injuries that would severely impair him. All Officer Owens saw was a red mark on Ryan's face. There were not marks on Ryan's chest. Ryan even refused any medical treatment. Ryan did not experience mistreatment. Opposing counsel would have you believe that Mr. Washington is violent and that he stepped beyond his role as a dad by getting physical with his son. Kansas law does not support this theory. In Kansas, minors have a heightened injury requirement for protection of abuse orders to be granted. For children, the bodily injury required by KSA 60-3102A1 was elevated by Peda versus Leach, a Kansas Supreme Court case from 1996, which is still good law. In Peda, the court held that in cases involving minors, the court must find the victim suffered, quote, substantial physical pain or physical impairment. Peda illustrated that disciplining a child by twisting their arm behind their back, pinning a child against a wall, and even putting soap in a child's mouth are discipline techniques, not abuse. While this standard is not a bright line rule, as opposing counsel noted, the act is not intended to dictate an acceptable parental discipline or unnecessarily interfere in the parent-child relationship. The court held that the discipline of children is not the chief evil at which the act was aimed. The discipline of children and the abuse of spouses, which was the intent of this act, share little in common. Again, under Barnett versus Barnett, the plaintiff must show that the father had placed the child in fear of imminent bodily injury within the meaning of one prong of the definition of abuse. There was no such physical contact. There was no fear of abuse. Kansas courts raised the injury requirement for minors because minors have avenues for relief that adults do not. Kansas has DCF and child in need of care cases intentionally to prevent against child abuse. Here, the system worked. A protection order here would only serve to punish Mr. Washington for his parenting style. This case scarcely rises to the level of discipline in PETA and rather demonstrates that other alternative methods for relief, which did not pan out, should also reflect on this standard. Petitioner Ryan has not shown, by preponderance of the evidence and under the light of all circumstances, that Mr. Washington's parenting did not rise to the level of abuse, that Ryan did not suffer substantial physical pain or impairment, and that Ryan was not in fear of, that Ryan was in fear of imminent bodily injury. Liberal application of the law is not warranted when the basic elements required for a protection from abuse order are not met. Mr. Washington made a mistake. Mr. Washington made a mistake while parenting his son, just as all parents make regrettable mistakes. Though Mr. Washington regrets how he disciplined Ryan, his remorse does not mean that he is guilty under Kansas law. Mr. Washington cares deeply for Ryan, is seeking to repair his relationship with Ryan, and only wants the best for his son. Mr. Washington is even willing to go to family therapy to improve his relationship with Ryan. Granting that order today would prevent the healing that Mr. Washington and Ryan need. Therefore, because plaintiff has not shown by preponderance of the evidence that Mr. Washington's mistake arose beyond discipline and that Ryan suffered the requisite physical impairment, we ask that you dismiss the protection from abuse petition. Thank you.